Welcome to the special edition of the Judgmental Podcast. We're just going to do question and answers. You can submit them at judge-y.com or you can submit them to Kentucky Christine on all of our social media platforms, Judging the Judges. All right, I'm Christine Miller.
I'm Hugh Barrow.
And we are two litigators that are just kind of done with the system and we want to talk about it all.
Yep, that's exactly right.
We've gotten amazing feedback. We want to do something special for YouTube and just kind of answer your questions. So submit them. We're going to do this every once in a while. I think we might try to start doing it locally within the community, like over a beer or something.
Yeah, I think that'd be great. We've gotten so many questions and so many good ones. It was hard. We picked some that were more introductory just to sort of get this started, but plan to do it in different ways pretty often.
So I guess I'm going to start with like a personal one and then we'll ask some of the questions just because to get the viewers to get to know us. But like, Hugh, what do you do for fun?
Oh man, I'm the type of person that when I get into a hobby, I go like way overboard with it. So I have a kit car, like a project car that I race that I have built a full garage and tools and all stuff around. I have a wood shop. I tend to either be in my garage working on something or building something just because so different than the work I did through the first part of my career where you don't see the product of what you're actually doing. It was always therapeutic for me to do something where at the end I can actually see exactly what I've done.
Yeah, and it's so weird because, like, for lawyers, we are kind of a different persona sometimes when we're practicing.
Yeah.
And I feel like you in particular were really good while practicing at, like, setting boundaries and just, like, not, like, I wasn't so much, you know?
Talk to my family. Oh, my gosh. I never felt like I was present for a long time. I finally started at the end setting those boundaries because once you have kids and you realize that you are there physically, I always made sure that I was physically there for everything. I spent as much time. But if your brain's not there, you're not even making those memories. And it just,
Yeah, well, it's like
to do it.
You were good though at like not as far as like oversharing or like when we were practicing together, like I didn't have any idea. Like y'all, he did this sign, he's got like a 3D printer, but like I had no idea like what all your hobbies were. Like I was the person at Motion Hour was like oversharing probably. Like, that annoying attorney.
I mean, it's just, I think it's more my personality. It wasn't strategic. And certainly when I met someone in my practice or represented someone that I had something in common with, especially car people or guitar people that were into music, I would share that stuff with. It's just by the time I started here, it was only a couple years into my career that I started a family, and I just I didn't socialize with people because I was trying to get home. Like as soon as I finished working, I was running a business, so I was just trying so hard to get home to spend what little waking hours I could with my young family that I didn't, hang out or, have hobbies that involved other people in the legal community.
Yeah, well, good. And that's smart too. Yeah, I was a happy hour girl with everybody.
Oh, I mean, listen, when I worked in DC before I had a family, my colleagues and we'd meet and go out all the time. And I missed that. That was absolutely wonderful. But I just never got into that here. I never had that here. Different stage in my life when I moved to Louisville.
So I got some questions from the people, and this is a really good one. How can GAL and FOC and parenting coordinator commit perjury and nothing is done?
Oh boy. Oh, that's a good one, even from a philosophical level. I think from a very high level, I think the truth is dead. We've put it to rest finally in society. There's no such thing as the truth. There's just what this person says versus what this person says.
And you say I'm the dramatic person.
And it certainly feels that way in court as well. I think, and this is so true, especially in family court, that yes, there is truth, but there are sides of things when you're dealing with family issues, and that something that may someone may be telling their story and it may be colored in a way that's not 100% accurate, but it's true to them. And the other person could be saying the exact opposite, but it's true to them. And I think to a certain extent that the gray areas just make it very hard for anyone in family court. It would be impossible for a judge to be the complete arbiter of black and white truth. And it's to the point where either you're cynical and you think, well, just everyone's lying and they're saying just what is most beneficial to them, or you are just saying that, oh, the truth is, this person's truth maybe is different than this person's truth. You start just looking at it as perjury. You just don't ever see anything made of perjury.
Mm-hmm.
I think
You don't even in any case really, like our perjury statute in Kentucky. I haven't looked at it in a hot minute. I think it requires reliance. I'm not positive on that.
Well, I mean, but it's just taking it to the next level when it's attorneys and we have specific duties in our practice. Rule 11 is to not draft and sign pleadings that you don't have a basis for believing are true. You can point that out in court where we're an attorney or that there's an affidavit or something that I've had instances where someone has filed a pleading and I've had a communication where I've provided the evidence as black and white, a statement like a bank statement or something that shows that that was not true. And it was before they filed that with the court. And it's just so clear that they are signing something that they knew and had been given the information that that was not true. And I can't get
And nothing happened.
Nothing. No, I filed a motion about it, but there's no penalty or anything. I'm not justifying it. I'm just sort of explaining how I think certain courts may have evolved to that, to where it might be different in a criminal court if you come in and you lie or something. I mean, certainly in federal court, the attorneys get fined, people get suspended. You just don't see it in family court. I'm not excusing it, but it's just, you just don't see it or hear
You don't
of
see
it.
consequences for FOCs, GALs, moms, dads, lawyers, really, for like stretching the truth. You know?
I think that might be my point is not just FOCs and GALs. I think it's just, they just are, it's just across the board that you don't see penalties for infractions related to truth.
And I think maybe that's like one of the huge problems. I know I say that too much, but it's like if someone isn't telling the truth, that's a big problem. But I don't know the answer, No. I don't know the answer.
No, I agree. I just, to the extent that the person asking the question may think that the FOCs and the GALs are getting special treatment and not being called out or punished for not telling the truth. Unfortunately, I don't think that's terribly accurate because it's almost impossible to get anyone punished for not telling the truth, no matter how blatant and how black and white and easy it is to prove. I've never had any luck doing it, which has frustrated me to no end.
Very frustrating. All right, you got a question for me?
Yeah, absolutely. Well, first, I think one of the things we haven't ever gotten into, but, we are the founders of Judgy and a forthcoming app that, is going to do a couple different unique things. But getting into the origins of that, what made you decide to start Judgy?
Well, I think it all goes back to the TikTok judge. I mean, obviously, which is kind of sad that that's still like a part of the story. But it's the notion that I quit practicing after an ex parte situation with the TikTok judge and another attorney that was very detrimental to a client of mine that I truly thought this client was I thought that her ex was going to hurt her or the children. Like literally, like I'm talking at one point during this saga, this was during the pandemic, was literally taking a selfie with the hashtag SHOOTR. I know we're going to get in trouble for saying that on YouTube, but like I genuinely, these people were in fear and it was a big deal. And the TikTok judge obviously was going to TikTok and not take things seriously and then, retaliated against me. And subsequently that led to the retaliation against my client who was the victim of just horrific things. And that's kind of led for me to be done with family law. And then I transitioned some, and when I saw the selfie recording of the TikTok judge where she selfie recorded herself during a domestic violence hearing, exploiting this family that was coming to her for help, I just realized that I had to do something. So I thought it was a Louisville problem. I know I say that all the time. I thought it was a Louisville problem. I figured if this dumbass can make TikToks, I can too. And it took off. And I realized that it was a global family court problem. And then I started seeing more and more just like of the judges that I was quote unquote raised on. We didn't have that demeanor on the bench. We didn't have any of that stuff. And I was growing and growing, and then it was just the notion of like, it's time to judge the judges like they judge us. Like, and they get to operate without any transparency, and you can feel it percolating where judges are the new cops. Like, you can feel the notion that the society is getting to this breaking point, and I want to have transparency, show the good judges, the bad judges. Then I partnered up with you, and you're the tech guy, and the app is coming, and I'm so excited. And it's just like, it's our flipping only 1 month anniversary yesterday of releasing the podcast.
No, that's mind-blowing to me.
Yeah.
Yeah, that's really mind-blowing to me.
So I just went on a tangent. But yeah, that's kind of what it is. And it's just the notion of like, this will help. I genuinely think it will help lawyers, litigants. It'll help judges do better. Like, ultimately, I want judges to just do a good job so the system will work. Like, I wanted to be a lawyer since I was a little girl. Like, it just shouldn't be like this.
Yeah, and I felt, I have felt on the podcast there are times where I didn't realize it consciously, but I'm sort of talking to specific judges to say, maybe look at how it's done in other places and you can avoid this giant mess that you're constantly in or you're creating for the people that are in front of you.
Yes.
Like, oh yeah. And it was so frustrating as a practitioner, but it never occurred to me to take the path that you did until I think I was out for about a month, and we sat down and had coffee and we're just talking about ideas.
For 4 hours.
And and I like you said, I thought it was more of a local thing, and you sort of pointed me in some directions, and I realized, oh, this is happening in...
Been there, done that, yeah.
There's so many people out there that are talking about it, so...
Oh, yeah, and just, like, the notion, like, mine was also out of desperation. Like, I knew when I left, I couldn't practice anymore because I knew I was going to have my clients were going to get retaliated against. And I was burnt out. I mean, there's self-serving mechanisms, too, in all of this. Like, I couldn't fucking do it anymore. Just literally couldn't do it anymore. And I don't know. I kind of just like stumbled upon it. And then I taught for a while and took a break. And I thought the Judicial Conduct Commission would hold the TikTok judge accountable. It's just, so naive of me. And it just seems like to just keep getting pulled back into saying like, and all I'm doing is saying the truth, like we aren't talking about them in any worse way than they have spoken to us directly.
Oh, no doubt. No doubt. And I think... yeah, when you get the pushback for saying something that is truthful or something that you just witnessed and you're just reporting it, that really solidified it with me to see some of the pushback.
Well, you're on the right track. Like,
that's exactly right.
And like, I mean, the people, and we're still learning. Like, we're just bear with us because we were a part of the system. I know.
That's depressing. Well, speaking of the system, here's a listener question about something that we see happen all the time over in court. And this is, can you talk some about silencing or interrupting pro se parties during hearings? Now, I'm not sure if they're talking about judges doing it or other attorneys, but we see both.
Yep. We saw it yesterday when we were in court, and this attorney was on Zoom and was completely talking over this pro se litigant. And it was Judge Johnson, right? Yeah. That just said,
let them finish.
Miss So-and-so, let them finish.
Yeah.
It is this notion of like, if an attorney has the room, they're just going to take advantage of a pro se litigant. And you're starting to see
what we do.
Some really good pro se litigants. But I do think that judges, I've seen some judges that coddle pro se litigants. And I've also seen some judges that will just interrupt, talk down to, and speak to them. The biggest thing I see is the speaking to them without empathy. Like the notion that like it's actually happening to them. Like it's as the lawyer, as the lawyer, it's not happening to me. I'm making an argument on behalf of my client. But the pro se litigant has to make an argument on behalf of themselves, but yet they're still experiencing it.
Yeah, I always figured that that's what was happening, that they're used to talking to the attorneys who are one step removed from what's actually happening. But it's a totally different thing when you talk to someone whose life is actually being decided in your courtroom. You have to approach them differently. And that's something that really stood out to me yesterday, is how certain judges did a really good job with that. There is
a litigant that was pro se at the time that has filed a writ and alleges that a judge told her to be quiet. Now, this is a litigant that was a victim of domestic violence. And that is a pretty, I think be quiet is a really just kind of radical, inappropriate, unprofessional way to talk to someone in a professional setting.
Well, you could just cut their mic.
That happened yesterday. But yeah, I do think pro se litigants are at a disadvantage, just the stress component of it alone.
Yeah, absolutely. And they have to know all the rules in the law. They're held to the same standards. And I remember how harsh it seemed, but how much respect I had for a judge the first time I saw that happen, where I had somebody, I was against someone who was pro se. They had plenty of money to hire an attorney, but they constantly relied on the fact that they didn't have one to try to get some leeway with the court.
Yep.
And the court had figured it out and just didn't do it, and held them to all the same rules and talked to them very respectfully, but I mean, threw the book at him every chance that she could. And I mean, it's a tough job. If you're going to represent yourself, you've got a lot of research to do and a lot of work to do that other people don't have to do.
Oh, and one piece of advice, I guess if you feel like that's happening, I think the best way to handle it would just be like, Your Honor, I have 2 points I'd like to make.
Yeah.
And that way, oh, Your Honor, I apologize. I wasn't trying to continue on and ramble. There are 14 things I want to say, or there are 3 things I want to say. Like, make a list of them. Because if you do that, the court's likely going to let you make your points. Not for 20 minutes, depending on the hearing, but that would be a good, and when in doubt, just start saying Your Honor over and over.
No, that's true. There are two things that I could recommend. That one, there are statements you can make that immediately should turn on the empathy from the judge.
What's that?
Where you say, I'm sorry, I did not mean to ramble, but this is, these are my kids, and it's, as a mom, I feel like, or a dad, just talk about, this is personal, make it clear that this is personal, and that may be why you may be going off and talking about 3 or 4 different things. But if the person that's cutting you off is being rude, if it's an attorney and they're being rude, don't let them get you frustrated. So much of the time, the attorney is trying to frustrate you, and what you want to do is, act shocked that they've interrupted you and be quiet for a second. When they finally shut up, say, Judge, may I please, and just meekly say, may I please finish the point that I was trying to make? And it will just stun the attorney, and the judge will let you do it. And you can sometimes turn the tide if they seem to be having the momentum by being very aggressive. Sometimes you can turn it around.
Great point. Oh, we got one more. How long should it take to make a final decision?
Oh, Lord. Oh, you're asking me?
I know.
Oh, gosh. How do we answer that? I mean, the typical attorney answer is it depends, is because it does depend. It just, if it's a very complex case that you got to dig through, it's going to take some time. But you would also, honestly, if you're going to have a big complex trial, you need to have scheduled and be prepared to put the time into getting that ruling out, and not just do it when you can get around to it. And it's not like things come to trial, especially in civil and family cases, without, you had no idea that this was going to be a complex case. You absolutely knew this was going to be a complex case. But that said, some things can be decided on the spot, and some counties decide, entire divorces on the spot. And while others take things under submission for a month to sometimes multiple years.
Oh, I think that's a good point, though. Okay, I didn't even think about the question from that perspective. How long after a hearing should a judge have to get an order out?
Oh, yeah. No,
like, let's say an hour-long hearing.
Oh, an hour-long hearing? I don't, I really appreciate, unless it's something where it's document heavy and a judge needs to review the evidence, I appreciate when I practice in places where they rule from the bench.
Which never happens anymore.
No, I mean, it does in other counties. You get rulings very often, and I can name counties where I could expect that if I go and have a hearing, I'm going to have a ruling when I walk out of it. Yeah, including some for all-day hearings.
Wow.
Sometimes, I mean, I've seen judges retire to chambers and come out 45 minutes later with a full ruling and say, somebody take notes, you're going to be drafting the order, and rule on all the things. They've gone back and considered it and met with
This is the craziest
staff.
thing I've ever heard. I've never even seen anything like that.
Oh, no.
But I think I think a full day trial the same day, I could see where, like, that's not enough time to weigh everything, maybe, but I'm okay with it.
This one was for an annulment. It was a single issue. It was a fascinating case, but it really came down to who you believed and what promises were made. And it was a single issue. So I felt that it was appropriate to rule after hearing the evidence. And honestly, right after, when you're having to deal with maybe a single issue and it's which side you believe, because they're both going to be saying the opposite, and one side of the case, one side of the other, the best time to make that judgment is right after you've heard it.
Yeah.
Not after you've been thinking about all these other cases, you come back to your notes and have to have your staff watch the video and fill you in and remind you what happened.
Well, that's how we do it with juries. They don't take 6 months under submission.
No, but the jury can take as much time as necessary to issue a ruling.
Yeah.
If you have tons of evidence, unless there's something that's so dispositive, they can come back and say, it clearly can't be this because we all agree that there's this one thing. If they're actually having to weigh the evidence, they could take weeks and weeks and weeks. And they spend all day looking at it. So.
How do you know you have a good lawyer? I'm going to tell you right now. And this is the answer. You have the ability to completely change the conversation.
That's funny.
Ladies and gentlemen, Hugh Barrow.
Yeah, well.
No, I mean, but seriously, it's true. It does depend. But let's say like 80% of the time, 1 hour hearing, how long should it take? I mean, obviously there's going to be weirdo facts.
I mean, so what do you have? Contempt, non-payment, deciding on what child support should be. All of those things should be able to be decided in a matter of days.
Holiday schedule, because a 1 hour hearing would be enough for a holiday schedule.
You should have that order on a few days.
Okay.
I mean, that's what I think.
I'd say a week.
If you can't get your calculator out from the bench and actually make a decision.
Yeah.
Now, I understand if you're giving people a full hour and you have something the next hour, you can't sit there and do that. You have to take it under submission. I'm not, there's no problem with that. But I don't think the delay in getting orders out is because it's taken so long to deliberate on it. It's
say it again, because that is
docket
so
management,
true.
just not sitting down to get the work done.
Just not doing the work.
Yeah.
They know how they're going to rule, or their staff attorney knows how they're going to rule 80 to 90% of the time. Now, obviously, when you're talking about a full day trial where you are literally fighting about who gets the car, who gets the bank accounts, who gets the kids, who gets the holiday schedule.
Did somebody misuse the accounts from the business? There's so many issues.
But still, objectively, and you tried way more of those, but a full day trial, how long reasonably to get a ruling out?
I always told clients best case scenario in a full day trial would be 2 months, but don't get your hopes up. And I felt like if around 6 weeks, I was satisfied with that. But I can't tell you whether I think that's good or if it was just I was conditioned to think that was fast, because that was fast.
Yeah, my gut reaction when I even asked the question out loud that I didn't know I was going to ask was, I think for a full day trial, I actually think if you get it within 3 months, it's reasonable. I really do, just because you want a full day trial, like you said, to be given more time. You are going to have to go back and review stuff because you can't remember all the numbers. I don't think that's unreasonable, And
it's a discussion that as an attorney you have with your client.
Yeah.
We are going to ask for more time. Understand that we are getting more time so we can go into more detail because you want to cover these things. But that means it's going to take longer to get a ruling because there's going to be more stuff that's dumped on the judge that they have to process.
And so I think another way you could pivot this, though, to this question, how long should it take to make a final decision? I wonder if what they're asking about is how there are so many temporary decisions that you can't appeal. You know what I mean?
Boy, that's a whole other, we could speak for hours on that. That drives me crazy.
Yeah.
That just really comes down to how quickly can they move a case forward to finality. And that's a...
And I think sometimes, I swear, I know this is, but I don't think they want to. I think they know somebody's going to appeal, or they know it's going to be all this stuff, and they just want to keep making orders temporary. Like in the baby case with Judge Ogden, she was doing that.
Oh, yeah. I've seen her do it more than anyone else, where you'll be standing at motion hour and she'll say, well, here's what I'm going to rule. And you say, you can't. The statute doesn't well, I'm just going to make it temporary. And she'll just handwrite temporary over it. It basically is a big middle finger to you that you can't really do anything about it. Isn't necessarily true. It just changes your remedies and it makes it more costly and time consuming and expensive for your client. But I don't know if it's that they don't want to make the final decision because they're going to be appealed. Because if they had, from my point of view, if a judge makes a ruling, controls the case, controls the courtroom, lets people know black and white, this is kind of how I feel about these kinds of things, here's what I expect from the parties, you're going to move it through and you're not going to end up appealed. It's when you do, you change your mind or you leave things ambiguous and you leave the case hanging out there, all the problems in that case are going to snowball to the point that by the time you try the case, there's going to be tons of issues. It's going to be outside of your control. You're much more likely to be appealed, I think.
That's a fabulous answer and great point. I don't know the answer to this, but from the time a case is filed, let's just say a simple LOL, but a custody action is filed, when should the parents have a final order that they could appeal if they wanted to?
Depends on where you are. I mean,
just like in a utopian world, but you're in utopia, but for some reason you still have mom and dad or mom and mom that can't get along, so you got to file a custody action.
Too high level, but when you think about all the things that are involved if you have a custody trial and you break down, they usually all correspond to time frames that you could put together, and maybe just running through them real quick, you could see why it might take a while just to get to trial from a practitioner's point of view, even if it had nothing to do with the judge's docket.
Yeah.
And that is, the filing of the pleadings, any temporary issues that you have to hear, child support, maintenance, temporary parenting schedule while it's pending. That has its own rounds of discovery and exchange, and that takes a while. If you're talking about a divorce, you have 45 days to do financial disclosures, and then the attorneys look at the financial disclosures, determine if they want to do discovery, which is another 30 days, usually extended out another 30 days. So then you're already looking at 3, 4, 5 months to get through the process of getting to a position to go to hearings and trial. And that's irrespective of the court, whether the court has even seen the case, looked at it or anything. That's just how long they take. From a court's point of view, as long as their docket is open, it really just comes down to, here's when you have the hearing, here's how organized I am and how quickly I get the case out. That doesn't really necessarily correspond to how long the case takes, because so much of that is just with the attorneys and is part of the process.
Yeah, I think though we're seeing now where cases are open or they're operating under temporary orders for 4 years.
Oh, absolutely.
5 years. I think that and this would be caveated on if the attorneys filed it or if the pro se parties file it, but a final determination subject to appeal should be available to parties within 1 year of filing the case.
You should be, at the very least, be able to get a final hearing. There are judges who just don't want to give final hearings. They want to treat everything like it's just another step and it's going to remain open forever. And that's just not how the process, that's not how the law works. No, and that's absolutely right.
I completely agree. All right. Yeah. Keep submitting your questions. We appreciate it. We really do appreciate you guys.
Yeah. Thanks, guys.
We need some justice. My life is fine, justice.